Concepts to know when selling your inherited house. Hi everyone, Kurt Lindsley here with Alabama Inherited Homes, and today we're going to unpack some key terminology and concepts that will help you in making informed decisions regarding the sale of your inherited home. So let's dive right in. First of all, let's talk about wills. Most houses that are inherited are passed on at the owner's death by the terms of the owner's will. Simply put, a will is a person's last chance to decide what they want to do with their property. It's a legal document with the authority to dictate the disposition of a person's property at death. And frankly, it's very difficult to contest no matter how apparently unreasonable it may seem to be. Yes, someone of testamentary capacity, sound mind, really can leave a huge fortune to their favorite charity or even their favorite pet, and nothing to children or other relatives. So where the maker of the will is the sole owner of a home, that means they have complete rights to it, subject to any liens or mortgages. And so what that means is they can draft a will in favor of legal heirs or whoever else he or she might want to inherit the property. An individual appointed to administrate the estate of a deceased person is the executor. The executor's main duty is to carry out the instructions and wishes of the deceased. The executor is appointed either by the maker of the will or, in case there was no prior appointment, by a court. The executor ensures that the transfer of title happens as stipulated in the will. Now, the existence of a will concerning the estate makes the process of inheritance indisputable and smooth. If there is no will in place, then the established state laws that govern intestate succession, meaning death without a will dictate the handling of property, and if needed, a court will intervene to settle issues. Now, the word probate carries negative connotations with some people, such that they work and plan to avoid it. However, probate does not have to be a difficult or drawn-out process. In fact, most states allow for simplified probate proceedings called common or informal probate, which allows for a more streamlined process. Typically, the executor files the will at the court clerk's office and fills out an application for appointment to the executor position. On the other hand, with solemn form probate, a legal complaint is filed with the probate court asking the court to open probate proceedings. Notice of the proceedings and a copy of the will are sent to all the decedent's heirs, whether mentioned in the will or not, as long as they would have inherited if the decedent had died intestate, meaning without a will. Common form probate does not require this step, although heirs can request a copy of the will from the executor. The solemn form probate notice typically includes a date for a court hearing. All interested parties have the right to attend this hearing, where a judge will admit the will for probate if he or she determines it is valid and meets the legal requirements. With most estates, there is no reason for the executor to go through a solemn form probate if common form probate is an option. An executor generally chooses solemn form probate only if he or she believes an heir or beneficiary might contest the will. Solemn form probate restricts heirs and beneficiaries from filing a will contest after a court-ordered date. Judges often hear potential will challenges during the initial court date when they decide if the will is a valid one. The will is either declared invalid or is declared valid and can proceed through the rest of probate uncontested. In common form probate, heirs potentially may have years to decide if they want to contest the will, which can leave the estate in legal limbo. Even after the estate settles and closes, there remains the possibility that an heir might file a contest to reopen it again. Check with your probate attorney for the most up-to-date information. So what if an executor mentioned in the will is either unable or is unwilling to serve? In that scenario, an appendix is created to appoint a new executor. But first, the executor should submit a declination letter, that is, if he or she is still living and not incapacitated. In this event, the executor could be selected by a majority of the beneficiaries. For the sake of minors and incapacitated heirs, the court appoints a guardian to look out for their interests. Probate is not required when there is no property to be divided under the terms of the will, and testamentary letters are not necessary to take control of assets in that case. It's essential to file the will of the deceased with the probate court. Unlike bank accounts, real estate properties will not automatically pass on to a surviving co-owner. To transfer the title of an automobile, probate is not needed, but real estate transfers do require it. In the absence of a will that names an executor, state law will list people who can legally discharge the responsibility. If there is a necessity for a probate court proceeding, then the court will choose the administrator based on a priority list. The intestate succession laws vary between states as to what happens to a deceased person's property who dies without enacting a valid will. If the deceased person was married, the surviving spouse will get the largest share of the estate. In cases where there were no children, the surviving spouse inherits the entirety of the property. The laws of every state dictate how children and other heirs inherit property differently, though, so be sure to consult with your probate attorney. So let's talk about taxes. Yay! Just kidding. Well, the authors of a will pass on their property with the best of intentions. Inheritors often must spend a great deal of money, effort, and time if they want to keep that property. The tax burdens accompanying inherited property are frequently a matter of concern and confusion. When inheriting a home, you need to know what kinds of taxes are attached to the home and what your obligations are. Now, for simplicity's sake, here are a couple categories of taxes applicable to inheritance to be aware of. The first is estate tax. Estate tax in the United States is a tax on the transfer of the estate of a deceased person. The tax applies to property that is transferred via a will or according to state laws of intestacy. Other transfers that are subject to the tax can include those made through intestate estate or trust, or the payment of certain life insurance benefits or financial account sums to beneficiaries. According to the IRS, the estate tax is part of the United Gift and Estate Tax system in the United States. The other part of the system, the gift tax, applies to transfers of property during a person's life. In addition to the federal estate tax, many states have enacted similar taxes of their own. These taxes may be termed an inheritance tax. If an asset is left to a spouse or federally recognized charity, the tax usually does not apply. In addition, a maximum amount varying year by year can be given by an individual before and or upon their death without incurring federal gift taxes. $5.6 million for individuals, $11.2 for married couples. The annual gift exclusion amount for 2021 is $15,000. And this note about the inheritance tax, heirs pay federal tax on the net worth of their inheritance. The net worth is the gross value less certain deductions, a mortgage that must be paid off in an inherited home, for instance, or a marital deduction for property inherited by a spouse. If the result is more than the IRS exempt amount for a given year, the heir must pay an inheritance tax at the federal income tax rate for the non-exempt amount. In our next video, we'll be providing some valuable insights for distributing property amongst family members with some practical tips that can help that process go a lot more smoothly for you and for your family. So be sure to tune in. Going through probate with inherited property is a challenging process, and that's why having a certified probate real estate specialist working for you can make a world of difference. I am here to help you, so give me a call toll free at 888-923-5547 extension 831. Or if you prefer, you can email me directly at kurt.lindsley@exprealty.com. This is Kurt Lindsley. I'll see you in the next video.